Hey everybody, welcome. Welcome to True Crime Wednesday. And I'm still in the throes of unpacking and moving, so still haven't quite got the lighting figured out yet. I have this very bright window right over here off my shoulder, and I'm trying to figure out how to balance that. I've got my ring light on, but it doesn't seem to be compensating quite well enough. So once I actually get a little further along in the move in, I hope to be able to play around with some other lights that I have and see if I can work it out. I know that it will change as time goes on because as winter comes along, it'll get dark earlier and I probably won't have the problem. So, um, but welcome. For anybody who's new to the channel, my name is Lori Hellis, and I am a retired criminal defense attorney and did prosecution too, so criminal attorney. And I wrote a book about the Lori Vallow story. The book will be released on September 24th. It's available for pre-order now. You can find all those links down in our show notes. And for those of you, the 106 who got the advanced copy of the PDF, you have now gotten 2 emails. The first one was the PDF that was sent to me by Pegasus, by my publisher. And that one, they told me, was the clean PDF. But y'all started sending me notes about the fact that you were finding typos and errors. And it turned out that they had sent me the unedited version. So the second PDF that you would have received actually is the corrected and complete manuscript, because the first one you got did not include the chapter on Chad, on his trial, did not include the epilogue completed, and it really wasn't the finished book, and I apologize for that. I will say that this adventure in publishing, I've learned a few lessons, and that was one of them. I should have double checked that. So I'm sorry about that. But what you do have now is the completed version. So tonight, I thought we would chat a bit about a couple of cases. One of them is the Black Swan case. This is, gosh, my mind just went blank. It's actually, I keep wanting to say Bridegan, and that is not right, because Bridegan is a different case. And here I've been listening to it all day long. So let me just grab that. The story is interesting. It is a story of a woman who met her husband very quickly. Oh my goodness, I may not ever be able to find it again. They're calling it Benefield, Ashley Benefield, sorry, Benefield, B-E-N-E, Benefield. So she met her husband, the husband and wife met. The husband was substantially older than her. He was in his 40s, she was in her mid to early 20s. And he had a 15-year-old daughter. His wife had died quite suddenly of an unknown heart condition about 8 months before, and he met her at a political rally, and they got together, and within 13 days, he married her. Had his vasectomy reversed so that they could try for a baby. She got pregnant very quickly afterwards, and they, while she was pregnant, she was having a difficult pregnancy. She was ill a lot, and so she decided that she needed to move back to her mother's, where her mother could take care of her, and they never lived together again. The baby, the daughter, was born a little bit early. The husband didn't even know the baby had been born, and the only way he found out was because his wife filed motions to for custody of the child. So, very odd case. They then I want to apologize up front for my gravelly voice. We are having some, Oregon is basically on fire right now. We generally battle wildfires, forest fires during the summer months. This year seems to be a particularly bad year. And what happens in the area around Bend and Redmond is that the Cascade Mountains separate us from the Willamette Valley. And what often happens is smoke settles in that valley in where Bend and Redmond are, creates an inversion, a weather inversion, and it keeps the smoke right down literally on the ground. When I took the dogs out this morning, my eyes were burning from the smoke, and it has been really bad all day. So forgive the gravelly voice. We'll try and soldier through together. So back to Ashley Benefield. The story continues that she was continuing to lead him to believe that they were going to reconcile and that they were going to move to Maryland. They were in Florida. They were going to move to Maryland together, where her mother had just inherited a home. They were all going to move there. She also knew, this is the prosecution's theory, is that they had done a psychological evaluation. It happens quite often in custody and parenting time disputes, where they'll have a custody evaluation that includes psychological evaluations. That report and the recommendations of the expert were due to be revealed in court within a day or two, and he showed up to help her load the U-Haul because they were going to go to Maryland as soon as this court hearing was over. There was some sort of a confrontation, and she claimed that she shot him in self-defense. Now, in Florida, before you can offer a self-defense defense, you have to have what they call a stand your ground hearing. And that means that the court has to review whether or not whether or not there's sufficient evidence to show that you were acting in self-defense and that you had the right to stand your ground. She shot him twice, and by the time she ran next door to the neighbor's house, he called 911. She was quite hysterical, and by the time police arrived, he was deceased. He had a 15-year-old daughter when he married Ashley. She is now 23, so that's how long it has taken to get this case to trial. But the prosecution says that she shot him in cold blood because she didn't want him to have custody of their child, and that was her motivation. The defense is still sticking to the self-defense theory, even though the court has ruled that she didn't meet the criteria for the court to find that she had the right to stand her ground. That puts her on kind of shaky ground. The question is whether or not the jury will hear that information. So we're in day 2 of trial, and I'm telling you what, this trial is clicking along. I would not be surprised if it is done into the jury by Friday. They're really speeding through the witnesses. Now, arguably, it's a pretty straightforward case. there are two theories as to the motivation for how and why the killing happened, but um, it, evidentially, in an evidentiary way, it's a pretty straightforward case. Um, she, the questions are whether or not she is going to have to take the stand in order to make her self-defense case, and the stepdaughter, her stepdaughter, the victim's daughter, has already been on the stand. And I think the jury is getting a decent picture um, of the theory of both the cases. So it's uh, it's probably not the most scintillating case, really, um, but it is the one that we have right now while we're waiting for a couple of other cases to start. Those of you who haven't seen it, Sarah Boone has posted a help wanted ad, or at least sent it to the judge and asked the judge to post it in his break room. And it is a help wanted ad for Sarah Boone looking for a lawyer. I don't think there are lawyers crawling out of the woodwork wanting to represent her, but it is. It will give you a chuckle if you pull it up. I didn't take the time to download it today. So there are a few other things going on. The Reed trial, the court has scheduled a hearing on the motion to dismiss, and we'll see what happens. I am not hopeful that the judge is going to overturn the verdict or enter a not guilty verdict on the two counts that the jury now says that they were unanimous on. I just don't think I don't see how legally. I know it's frustrating for those people who believe Karen Reed is not guilty. It's incredibly frustrating because the jury spent 10 weeks listening to all of this information, found unanimously that she was not guilty on two counts, didn't fill out the jury forms correctly, and so now we have a problem because the jurors come forward and say, "But we found unanimously that she was not guilty on those two counts." I don't think the judge is going to go back and unring the bell. So the state is at this point saying they're going to retry her on all the counts. Um, I think their only hope is that the state may decide that they don't want to retry her on all the counts, and they may only try her on the one count that the prior jury was hung on. But I wouldn't hang my hat on that either. So, um, and we have a fairly large development in the Kohberger case, which I want to talk about here in a minute. But um, there still appears to be there is still are still some motions to be heard in Delphi, and Judge Gull is continuing to dig her feet in and deny motions left and right. I don't know that that case is ever really going to. I don't know that that case. There's any hope that Judge Gull is going to recuse herself. And we really don't know what's going to happen in that case. One of the problems is that Judge Gull has ordered at this point that there be no cameras in the courtroom. And she continues to double down on no live streaming of the trial once it starts. That's unfortunate because she's already under fire for being biased and not listening to the defense. She's also got a lot of strikes against her, and I think it just makes her look worse. So we'll wait to see how that works out. Bob Motta from Defense Diaries is one of the people who will be in the courtroom and will be giving us live updates as things happen. And yes, I know that there has been some sort of a dust up between Bob and Allie and the folks at Murder Sheet. I don't generally follow Murder Sheet frequently. I didn't see the episode. I have no idea what the argument is, and I don't go there. I will tell you that as a defense attorney, I find Bob and Allie very relatable, understanding, and accurate. Understandable and accurate. So I'm going to continue to tell people as Delphi goes on, the only access you are going to have is going to be through the people who are actually in the courtroom. And I know that Bob intends to be there. To be honest, there is so much drama online. And believe me, there's been a lot of drama this week, thanks to the political scene. But there's so much drama online. And I have tried really hard not to involve myself in it. I've tried really hard to stay Switzerland, kind of like Gigi from Pretty Lies and Alibis does. I talk with everybody. I will talk to anybody who wants to chat, but I don't get in the middle of, I'm just going to say it, pissing contests between creators, because I don't have the energy for it. It doesn't interest me. I want to expend my bandwidth preparing for my shows, writing books, and I don't want to be caught in the crosshairs of some feud that doesn't really involve me. So I will say I have found the Matas to be very ethical lawyers, and that's where I come down on it. What's going on in the true crime community and in the online space is over my head at this point. So that's all I know about it. I know that Bob and Allie have been interested in and have covered Delphi since the beginning, since Richard Allen was arrested, and perhaps even before that. I think they give a really good rundown of the pleadings in the cases, the documents that are being filed, and I think those are important things to understand. So that's kind of where I come down on the internet drama. There was some pretty big news in Brian Kohberger's case. Now I have a document up here on my screen, and I am going to share my screen with you so that we can look at it together. This is I know that it is not going to be huge, and I will tell you that when I see Emily Baker go, let's embiggen that, and I try it, I have not been successful. But what I do want to talk about, so if anybody knows how to do that, let me know, because I'm still, there we go. Well, that's a little bit bigger, because I'm still learning these things. So this is, the document is the memorandum in support of the motion to change venue on Kohberger's case. And a change of venue is when one side or the other asks the judge to move a case out of the jurisdiction where the case happened. So in the law, and particular in criminal law, you must bring the charges in the county where it happened. And that sometimes can be tricky if it's a small county, as we saw with Lori Vallow in Fremont County. And and the jury pool is small. So we're seeing that very same sort of environment and that same sort of argument in Kohberger. So they start out, Ann Taylor, Brian Kohberger's lawyer, starts out by really going through the issues and then framing the questions. So she gives what she calls an abbreviated factual background and then goes on into argument. She says Brian Kohberger cannot receive a fair trial in Latah County. Court TV called it Fremont County. Fremont County was Vallow. So shame on you, Court TV. It's Latah County, as protected by his rights under both the US Constitution and the Idaho Constitution because of the pervasive, inflammatory, and often inaccurate publicity and the small size of the jury veneer. The jury veneer is another word for jury pool. So what they're saying is that, as happened in the Vallow case, we also have the situation in this case, that this is a small county. It's not widely populated. The largest employer in the county is the University of Idaho, followed by the government, county government. So it isn't a very big county. You'll see a little bit later on when Ann Taylor outlines the statistics. She is also working with an expert who is a jury expert and an expert in surveying and in changes of venues. So we'll get to that in a bit. She says they acknowledge that changes of venue have to present prejudice, that it's not enough to just show that the case has been widely talked about. There has to be prejudice that requires the change of venue in order for him to get a fair trial. So she argues that in this case, it is an extreme case in that the atmosphere in Latah County is utterly corrupted by press coverage requiring a change of venue. I don't disagree, and you'll see these statistics are pretty interesting. So she cites case law because case law is where we get our rules. So let me talk a little bit about how lawyers write and legal writing. Because sometimes when y'all listen to me or you read a motion, sometimes they don't always make as much sense as you think they ought to. But I think that if you understand the format that lawyers are writing in, sometimes that's helpful. So when you write any kind of a legal memorandum or a motion, it follows what we call IRAC, I-R-A-C. That is the issue, the rule, the argument, and the conclusion. So you see her lay out the issues, including a little bit of background information. Now she's going into the rules, and that includes citing both the statutes, both Idaho statutes and the case law that has interpreted statute and given us a finer, more nuanced rule. So now she is going through the rule. The threshold in Idaho is a reasonable likelihood, as the court in Haddon stated. It is sufficient for the accused to show there was a reasonable likelihood prejudicial news coverage prevented a fair trial in violation of the Sixth Amendment to the U.S. Constitution. Now, that particular decision happens to be a federal Supreme Court decision. So Ann Taylor goes on to list the rules, and so then she begins to talk about the population of Moscow is only 41,000, and of that, 19% are under the age of 18, and 19 are over the age of 65. The cutoff in Idaho is age 70. So at 65, you can tell the court, I don't feel like I can serve, but at 70, you're exempted. So the census statistics reduce the eligible population on age alone by 38% for a total of 25,000 available population before any juror qualification questions are asked. So remember, this is a death penalty case. So what they will do is they will send out juror questionnaires the way they did in Daybell and in Vallow, and they will bring in a pool of potential jurors. And they will begin asking case-specific questions about this particular case. The first thing they're going to do, because this is a death penalty case, is they're going to ask to death penalty qualify the jury. Meaning they're going to ask that if there's anyone on the jury, they're going to disqualify anyone on the jury who says outright that they have a moral or a philosophical disagreement with the death penalty and that they could not impose it. So that would be the first question. Then from there, they would begin inquiring about what sort of exposure the jury has had to the facts of the case. Well, let me back up. The first thing they would do is ask the death penalty question. The second thing they would do is ask them if they know, have had contact, or are related to anybody involved in the case. Once that threshold is over, then they would begin asking questions about the actual facts of the case. So as Ann Taylor goes through the reasoning in the memorandum, it really becomes clear that Latah County is going to present some real serious challenges. So now she is continuing to lay out all of the rules and what the court uses to make decisions. And then she says, change of venue is necessary and appropriate pursuant to statute and rule. So the first thing she said was, change of venue is necessary and appropriate because of the following case law. So that's, she's laid out the issue. Now she's going through the rules. So the first thing she did was went through the case law in the rule and the rules pertaining. Now she's going to go through the actual statutes that are in Idaho law and any court rules that are applicable. So she started out with the generalized idea that changes of venue are appropriate when there is too much pretrial publicity to the point where it is extreme and taints the jury pool. So I'm trying to go slowly so that I don't make y'all dizzy. But let's so going through this, they begin to talk about Ada County. So the Ada County Courthouse can accommodate this trial. There are large courtrooms with adequate space and tables for the attorneys and Mr. Kohberger. The large courtroom provides space for each counsel to keep materials and necessary conversations out of the eyesight or earshot of the other party, spectators, and the media. Due to the size, the courtroom can accommodate a large number of spectators, and there is overflow space available for the public to watch the trial. That's exactly what we saw in Lori Vallow and Chad Daybell's trials. Ada County has adequate security for the safety of the parties, court staff, and the jurors. There are multiple jury rooms and many private restrooms away from the public that can accommodate the jurors, and the courthouse and security are set up to assist jurors. They have a jury coordinator and a jury commissioner. So they point out that Latah County is difficult to get to, that the closest airport is has few direct flights, and the most witnesses would be required to travel to Spokane, Washington, rent a car to drive to Latah County. That's several hours away. So they conclude this is no ordinary case. Brian Kohberger is accused of killing 4 people. The state seeks the death penalty. His constitutional rights must be carefully guarded, and therefore, rarely does even a small community come together in both number and quality of unity as has happened here. She makes the point that, of course, because these were young people, they were students at the university, that the victims were of great interest to everyone. And so she makes the point that the community really came together in support of the college, in support of students, and that heightened people's awareness of the case and the facts of the case. So now I'm going to brace yourself, because I'm going to scroll through quite a bit of this. The next thing she does is she includes as exhibits all of the press releases that were sent out by law enforcement from the very beginning. So she goes through and outlines, and there are many of them, and I'm not going to read them all. We're just going to kind of zip through those, because I want to get down to the actual affidavits, the actual information about the case, and here we go. And including the information that was provided by their expert. His name is Brian Edelman. It's E, so I don't know if it's Edelman or Eidelman, but anyway, he is an expert. He is the co-founder of Trial Innovations, a national full-service jury research firm, worked as a trial consultant for 20 years. And he points out that he has worked on some very high visibility cases, including State of Florida versus Nicholas Cruz, who was a school shooter. He comes right to the point. First of all, he talks about what they were tasked to do. They were tasked to evaluate whether there was extensive and prejudicial pretrial publicity, and then to determine if the media coverage had impacted his ability to get a fair trial, and then to evaluate potential other alternatives for other counties. Then he goes right to his opinion. It is my opinion that the residents in Latah County have been exposed to excessive prejudicial pretrial publicity and social media surrounding the murders of Kaylee Gonsalves Madison Mogan, Xana Kernodle, and Ethan Chapin. The coverage of Brian Kohberger included interviews with former friends and students and old posts from his social media accounts dating back to years. The publicity painted a picture of a disturbed individual capable of committing violence. The media also saturated the jury pool with potential trial evidence and details, some of which proved to be false or misleading, that create a presumption of guilt. The pretrial publicity is replete with references to GPS phone data from the defendant's phone, video footage of the alleged getaway vehicle reported to be his make and model, evidence left by the killer at the crime scene, DNA results, and erroneous connections to the victims. Much of this information came directly from the probable cause affidavit shared with the media by Latah County Prosecutor Bill Thompson during a December 30th, 2020 televised news conference. With the media in attendance, Mr. Thompson encouraged them to share the true facts with all of your readers and the watchers and the listeners and all the people who are interested and really need to know what is going on. These killings sent shockwaves through the local community and generated widespread panic during the 6-week search for the killer. During this time, there was tremendous pressure on law enforcement to find the person responsible for the murders and share details about the investigation with the public. With investigators reluctant to share information before making an arrest, rumors and misinformation proliferated via informal communication channels and social media about the crime. For example, the victims were bound and gagged, the killer called 911, and the killer. For example, it was a driver who took the victims home. The roommates were involved. Kohberger had killed before. During this time, it was reported that detectives received 2,645 email tips, 2,770 phone tips, and 1,084 digital media submissions from the public. Residents remained on high alert and feared that the killer could strike again. Many students went home for the Thanksgiving break early and did not return. On December 10th, University of Idaho spokeswoman Jody Walker told the media that an estimated 25 to 40% of students had not yet returned to campus. One of the victim's sisters encouraged students to go home rather than risk their lives. To the students of the University of Idaho that are still staying around campus, leave. Your grades are severely less important than your lives. Police Chief Fry tried to reassure the public that everyone was safe, and the University of Idaho drastically increased campus security. So then we know the Moscow community joined together to support the victims and their families. A candlelight vigil was held on campus and thousands of stickers were handed out. Another candlelight vigil was held on the 1-year anniversary of the murders. In addition, a tree that serves as the centerpiece of Moscow's Friendship Square was decorated with messages written by community members to honor the 4 victims during the holiday season. The Healing Garden was inspired by the murders and created to memorialize all students who had died while attending the university. The King Road home where the victims lived was demolished based on requests from the student body. We heard from students in the area that they were ready for the house to come down. However, the decision was met with criticism and fomented another round of speculation and misinformation. So if you recall, there were quite a few people, including some of the family members of the victims who did not want the home torn down. They were concerned that the jury might want a jury view. I am not entirely sure that jury views are all that helpful. If anything, they are often helpful to the prosecution, and here's the reason why. A story hits different when you are standing in the actual place where it happened. So if you remember, they did a jury view at Alec Murdaugh's house. That was requested by the defense. I really felt like that was a huge mistake because it allowed the jurors to actually stand in that space, and a space where something horrible has happened feels different. What happened was the landlord, who owned the building, promptly donated it to the university. And he did that for a reason, because there was a lot of looky-loos. There were a lot of people who were attempting to get in and steal souvenirs. There was a lot of just kind of sick behavior going on. They did not want that. The landlord didn't want to provide the security, so he gave it to the university. Then the university had to pay for almost a year's worth of 24-hour security on the place. So that led to the suggestion that the home be demolished. Remember that crime scenes these days are documented with laser systems that allow them to give absolute precise measurements and to be able to literally reconstruct a 3D model of the property. So I don't know that it was so critical that they preserved the house. And I really understood completely why they decided not to. So then the expert starts really getting into the numbers, and they're pretty surprising, actually. I mean, I'm not surprised, but I think that a lot of people will be surprised at the numbers. A community attitude survey was conducted to assess the impact of the media coverage on the Latah County jury pool. Approximately 98% of the survey respondents were familiar with the case. In addition, community members have more than just a passing familiarity with the crime. Approximately 68% of survey respondents reported that they have followed the case somewhat or very closely, with 29% falling into that latter very closely category. In addition, 79% of survey respondents recognized at least 5 of 9 media items tested in the survey, and 52% knew 7 or more of those items that they were asked about, those facts that they were asked about. 81% of those familiar with the case had read, seen, or heard that police found a knife sheath on the bed next to one of the victims. And 67% were aware that DNA found on the sheath matched Brian Kohberger. In addition, 86% of Latah County survey respondents heard that the defendant owned the same type of car recorded on video that to be driving in the neighborhood when the killings occurred. And 79% knew that cell phone tower data purportedly showed Kohberger made several trips near the victim's home months before the killing. These findings are particularly concerning given that all these media items, which come from the probable cause affidavit mentioned during a December 30th press conference, were significantly related to prejudgment. For example, 72% of Latah County prospective jurors who knew that police found a knife in a sheath, 75% of those who heard there was DNA match believe Kohberger to be guilty. So 72% who heard about the knife and 75% of those who heard about the DNA match believed he's guilty. So they argue this finding puts the defendant at a distinct disadvantage at the start of trial. Many of the incriminating details widely reported in the media are in dispute, including the claim that Kohberger's vehicle was placed near the scene of the crime with video footage. However, the burden of proof has shifted to the defendant, who must change jurors' pre-existing opinions regarding the evidence against Kohberger developed from exposure to biased media coverage. So that's interesting. What they're saying is that that the people who have heard about the case, most of them have already formed an opinion about his guilt or innocence. And so rather than starting from the position of that Brian Kohberger is presumed innocent, they will be starting from the position that he is guilty. And that is an unconstitutional shifting of the burden. And it is it's created by a lack of due process. So they also talk about the fact that rumors have proliferated in Latah County. For example, survey respondents reported that Kohberger had a bad history with women, was responsible for other murders in Pennsylvania and Washington, bragged about committing the perfect murder, and was acting strange after the murders. Others reported he was obsessed with one of the victims, had dated her, tracked her location at all times, and had been in the house in the past. Survey respondents also mentioned rumors about drugs, other suspects involved, an online business that was sexual in nature, and parties at the victim's house. So the next question is, if not Latah County, where else? They point out that that the extent of personal connections among the Latah County residents in Moscow to these murders is extraordinary. Approximately 88% of those familiar with the case had talked about it or heard others talking about it in person or online. 78% of the survey respondents lived in Moscow or knew someone who lived there at the time of the murders. Another 25% reported that they or a family member was a student or employee at the university. A sizable percentage of the prospective jury pool was also connected to the murder investigation. Approximately 22% of Latah County survey respondents are employed or know someone employed by a law enforcement agency involved in the investigation. This was something that we saw in Fremont County as well. Now, you may recall that the judge granted that change of venue, but there was nowhere near the in-depth analysis presented to Judge Boyce that has been presented here to Judge in Latah County. So, but you will remember that in Fremont County, there was a large percentage of the population in Fremont County that either knew one of the deputies, had dealings with one of the deputies, or had a family member who knew them or had been involved with them. So the smaller the jurisdiction, then the more likely it is that you are just 6 degrees of separation from Kevin Bacon, as they say. You know, it's much more likely that you are just a very short distance away from some sort of a connection to somebody in the law enforcement community. That's true in Moscow. And it says Latah County residents lived in a perpetual state of fear during the search for the killer. Many survey respondents reported that they started locking their doors for the first time, and parents feared for their children's lives. More than half of survey respondents reported that they or someone they knew experienced higher levels of stress, anxiety, or fear during the manhunt. That number increased to 63% for Moscow residents. The comparison surveys also found significant case recognition and bias arose in alternative venues. Approximately 90% of Canyon County and 84% of Bannock County survey respondents were familiar with the case. The prejudgment rate in Canyon and Bannock counties was also high. 69% of Canyon County and 76% of Bannock County residents familiar with the case reported that the defendant was guilty of the murders. Ada County, that's where Boise is the largest county in Idaho with 406,068 residents over the age of 18. Its population is more than 12 times the size of Latah County. Approximately 93% of Ada County survey respondents have read, seen, or heard about this case, and 68% believe Kohberger is guilty of murder. However, there were important differences between Latah and Ada County jury pools. Ada County residents are far less invested in the case than their Latah County counterparts. Only 15% reported that they followed the case very closely compared to 29% of prospective jurors in Latah County. They were also less familiar with prejudicial media items. Approximately 63% had read, seen, or heard that police found a knife sheath on one of the victims' beds, compared to 81% in Latah County. 52% had heard that DNA on the knife sheath matched the defendant, 15 percentage points lower than their counterparts in Latah County. Ada County survey respondents were also less familiar with prejudicial misinformation widely reported in the coverage and disseminated via social media. For example, just 35% had heard that the defendant allegedly followed one of the victims on social media. Now, I want you to recall that the bulk of this information was information that was in the probable cause affidavit or was extrapolated from that probable cause affidavit. Ada County residents also had fewer personal connections to the case. Only 20% lived or knew someone who lived in Moscow at the time of the murders. Just 4% reported that they or a family member was a student or employee at the University of Idaho in Moscow. And in addition, only 2% of the Ada County survey respondents are employed or know someone employed by law enforcement agency involved in the investigation. Ada County community members did not suffer severe levels of emotional distress during the search for the killer. Only 34% of prospective jurors reported that they or someone they knew experienced higher levels of stress, anxiety, or fear during the manhunt, 25 percentage points lower than in Latah County. So, in conclusion, given the extent and the nature of the pretrial publicity in Latah County, coupled with its negative impact on the jury pool. It is my opinion that there is a reasonable likelihood that the defendant's constitutional rights to a fair trial have been undermined. As such, it is my opinion that remedial measures, including a change of venue, are appropriate to ensure a fair and impartial trial. Then he goes on to list his qualifications and the qualifications of any other people that were involved in the research. There are a couple of other attachments that are part of the description of their process and the results. Sorry, trying to get past all this. So then you see the curriculum vitae for Brian Edelman, Dr. Brian Edelman, as well as some of the other people who participated in the study with him. So all told, it is 309 pages, but I've tried to condense it and to really get to the meat of it. They don't believe that the counties surrounding Moscow, surrounding Latah County, that would be Canyon and Bannock, didn't feel that either one of those counties was any less impacted by the pervasive media. But they did feel that Ada County was less prejudiced by the pretrial publicity. And that makes a certain amount of sense, particularly after what we saw in the Vallow-Daybell case, because as you remember, they were able to seat a jury in the Vallow-Daybell cases, Vallow and Daybell cases. So they were able to seat a jury for Chad Daybell after Lori's trial had been completed. She had been found guilty and sentenced, and her trial had been broadcast at the end of each day. The audio had been broadcast. So anybody who was really interested in the case was listening after court was over. And and then Chad's was live streamed, but the point being that even though Lori's trial had occurred and Judge Boyce was very concerned about pretrial publicity and whether or not Chad's case was going to be prejudiced by that, they were able to seat a jury, and the jury was able to reach unanimous decisions. So it seems to me that this is a very thorough motion, a very thorough memo about the findings of the surveys. It's very thorough, very in-depth, and I think very persuasive. I cannot imagine a judge not granting the change of venue motion based on this memorandum and the results from this survey. So I really expect that we're going to see a change of venue and that it will come to Ada County. It really makes a lot of sense for a variety of reasons. They pointed out that the Ada County court is much more prepared to handle a high visibility case than little Latah County is. So I don't think that is going to change. I don't think that is going to change the date of the trial. I think that that date is going to stay. It is currently set for June of 2025, June 2nd. And I don't think that is an unreasonable time to set it. So I don't think I don't think that if the judge grants the change of venue motion, he would then accelerate the trial date. I could be wrong. A lot of that might depend on whether or not the victims' families have some input into what the trial date is going to be. But remember that Ada County now has to plan for what is likely to be as long, if not longer, than the De Belvallo cases, and easily, as heavily publicized and as heavily attended as Vallow was. So I think it's reasonable that June 2nd will be the date. I actually would be surprised to see it move further out unless there is some sort of conflict that Ada County can't accommodate. So I expect we're going to see that trial go forward, but I think it's going to go forward in Ada County. And I think that's the right decision. Looking at those statistics, understanding the mood of a small town and the way that this impacted that town. I mean, when you look at the fact that there are nearly 5,000 people who are employed by the university, and all of those people directly impacted by one of their students, 4 of their students being murdered. So I definitely can see that it makes perfect sense to move this case to a larger jurisdiction where there's going to be a broader and more diverse jury pool and a better likelihood that people won't have studied the case in depth, unlike all of us who certainly have studied the case in depth. So let's see, Karen, we talked about Karen Reed. There is going to be another trial, a status conference. They had a scheduling conference this week, sorry. And at that scheduling conference, the judge set the date to hear the motion to dismiss. Jen is telling me I need to take the darn document down so that y'all can see me, which is why I answer my texts. Okay, so the judge in Karen Reed set a date to hear the motions on the motion to dismiss the case based on the jury finding not guilty on 2 of the 3 charges. As I say, I don't think that's going to go anywhere, and I think that you're going to get trial setting at that hearing. I think the judge is going to go ahead and set a trial. And yes, I do think that it will continue to be Judge Canoni unless the defense can make a case to have her disqualified. I don't know at this point whether or not they're going to be able to make that kind of a case. So, and then in Hannah Gutierrez Reed case, that's the Alec Baldwin case. Alec Baldwin's case was dismissed with prejudice due to misconduct on the part of the prosecution. And Hannah Gutierrez Reed's attorneys then promptly filed a motion saying that the prosecutor committed the same misconduct in her case, but of course they didn't know about it because it didn't come out until Baldwin's trial. And so they want her charges dismissed as well. I think that is a tougher ask for a number of reasons. I think there is at least some reason to believe that they were aware of the evidence that came in at Baldwin's trial. And I also think the argument is that the relative responsibility is different in that case as well. So we'll see what happens when they hear the motion to dismiss. I thought the judge did set a new trial date late January. You know, I think you're right. Yeah, thank you, Jen. I saw that starred. Rachel, I think you're right. I think that she did already set a new trial date in January. Now that you mention it, that rings a bell. So we'll know more about how that goes forward once she rules on those motions, on the motion to dismiss. So that's about all that's going on. We have a lot of stuff coming up, but nothing immediately. We have Sarah Boone, we have Delphi, we have Donna Adelson. There was a pretrial conference on Adelson. It basically was a scheduling pretrial, and it literally was done in about 3 minutes. I mean, the funniest part about the whole thing, or the most interesting part about the whole thing, was the fact that the judge was concerned that the sound might not be correct as he was connecting with Donna in, I'm looking for last week's notes, as he was connecting with Donna on the video, on the Zoom call. And so he said, I want to know whether or not we can hear you. So please tell me the name of your high school mascot. And she said, oh my gosh, it's been so many years, I can't remember. But it was a little bit of a light moment in a heavy court appearance. She managed to behave herself and not demand to see the manager. And there are some additional text messages that have come up since Charlie's trial, because they came up as a result of finding Charlie guilty, and Donna texting Wendy and saying, you know, your brother's done everything to protect you, and now you're not guilty. I think that's going to be a tough one for the defense to explain away. So somebody says theirs was a tiger. My high school, believe it or not, I went to high school in Vancouver, Washington, and our high school mascot was the Plainsman, for pioneers. It was the Plainsman. So I'm ready to take some questions from anybody who's got questions. We're in a little bit of a lull right now. We haven't got any really high visibility, juicy trials coming up, but there are a few. A lot of you have asked me what my next project might be, and I'll tell you what I'm thinking about. Now, I don't have it on paper yet, so until it gets on paper, I'm still just sort of noodling it, but I'm getting closer to formulating a book proposal. And the idea is to look at cases where grandmothers have in some way influenced people to commit murders so that they can get custody of their grandchildren. And so there are several cases that I'm focusing on. One, of course, is Adelson out of Florida. The other one is Piketon, Ohio, the Pike County murders, the Wagners. And then the last one is the case out of Oklahoma that happened recently, and the name escapes me, where the mom was going to meet the grandparents at a halfway point to exchange the child for visitation, and never showed up. And it was determined later that she and the person who was volunteering to provide supervision were both murdered by the grandparents. So interesting cases. You all know, because you've gotten to know me. God's Misfits. Yeah, I don't remember Grandma's name. That one does have sort of an odd religious overtone. The other two, not so much. But you all know me well enough now to know that the stories that interest me are the ones that have layers of facts and layers of detail. That's what makes it interesting to me. And you all know that I am Tiffany Adams. That's Grandma's name. You all know that I am most interested in the things that I can really go down the rabbit hole and ask the question, why? And it in the idea of what uh, mental health professionals are calling toxic grandparenthood is interesting to me. And not just because I'm hoping that I might be a grandmother soon, not just because of that, not because I'm worried at all about being a toxic grandmother. Of course, I'm worried, as in the grandmothers who commit the crimes. That's right, Rachel. Yeah, these are the things that interest me are uh, the reasons why a grandparent would go to the lengths of um, soliciting murder, having one of the children's parents murdered in order to retain contact or custody. Um, so, yeah, I mean, it's pretty clear Donna Adelson has been charged with murder. Tiffany Adams has been charged with murder. And is her name Andrea or uh, Wagner? Angela. Angela Wagner. Yeah. So those would be the three cases that I would start with to really sort of dig into the facts and look at what they have in common and where they differ. One of the things, of course, is the the economic factors. I mean, the Adelsons were quite wealthy, the Wagners not so much, and I don't think I know enough yet about Tiffany Adams. There's some suggestion that one of them owned a great deal of property in a small town and that they may have had an undue amount of influence in a small town. So that's going to be looking at how they're the same and how they're different. I think it will be really fascinating. So that's what I'm thinking about. Once I get a book proposal together, I'll let you all know what comes of it. So, but I'm excited. I'm excited to dig into the next project. So, speaking of that, I am still working on a book signing in Boise. I'm still waiting to hear from Rediscovered Books about whether or not I can do a book signing. I did reach out to the bookstore, I think it's called Barn Owl Books in McCall, and they were very enthusiastic and said they would love to schedule something with me in November. So I'm hoping that I could do Boise and McCall since they're fairly close together, all in a couple of days span. And so I'm doing that. September 26th, just 2 days after the book releases, I will be at the Cedar Hills uh, uh, location. Sorry, my brain's getting a little tired. I will be at the Cedar Hills location of Powell's Books in Portland, Oregon, to do my first author event and signing there. I will also be at Roundabout Books on October 10th on 10/10 in Bend, where I will be doing a book signing there. I'm really excited about that one. I did my master's program in Bend, and so I have a really lovely writing community that I'm already plugged into in Bend, and I'm excited to be able to see a lot of those folks and get together and share successes. It's been really exciting and fun to to share as we've all gotten a few years out from our master's program and have started actually publishing and getting recognized for our work. So it's exciting and it'll be fun to share those successes with a lot of my master's MFA cohort. So, so any other questions, folks? It doesn't have to be about what we've talked about yet. It can be anything. Rachel, this is a really good question. I try not to get political, but I think this is a very good question when it comes to judges. Local judges generally are elected, and they generally, often what happens is a judge leaves midterm, and then the governor or the legislature, depending, generally it's the governor, appoints their successor, and then that person runs as the incumbent at the next election cycle. What that means is a lot of judicial seats are uncontested. They are not, the judge runs as the incumbent and they run unopposed. But in cases where you do have more than one choice for your local trial court level judge, there are some things that you can do to take a look at local judges. Probably one of the best things to do is do a search within your local TV station or news network or newspaper. Do a word search for that person's name, and you will see the cases come up that that judge has presided over in the past 2 or 3 years. And that then can help you look at the kinds of cases that person has been overseeing, and whether or not they were cases where there was any sort of controversy involved. We really want our judges to be umpires. We really want our juries to be the finders of fact. The only time we really want our judges to be rendering opinions is either on the legal issues in motions, the evidentiary issues in motions, or if they are specifically tasked to be the finder of fact. Now, there is such a thing as a bench trial. The defendant in a criminal trial can opt, waive the jury and opt to have the decision made by a judge. And in that case, the judge stands in the place of the jury and then becomes the finder of fact, evaluating who they believe, who's more truthful, all of the things that a jury would do. But for the most part, what we really want our judges to do is we want them to be umpires. We want them to call balls and strikes. We want them to decide overruled, sustained. We want them to do that. We do not want judges who are proactive. We don't want judges who are stepping in and trying to try a case that rightfully the trial decisions are left with the lawyers. And I will tell you that there are many judges out there who become more proactive than I think is appropriate, who involve themselves in the actual trial decisions in ways that may not really be the most appropriate. So when you're looking at local judges, of course, if you have time on your hand, you can always go sit in their courtroom for an hour or two. See what their demeanor is like. See how they treat the people who come before them. Sometimes it can be real eye-opening to see how a judge treats the defendants that come in front of them or the litigants that come in front of them, because of course judges do both criminal and civil. Those are a couple of good ways to take a look at whether or not you've got a judge who is controversial. And I think another really good way is if you happen to be in a jurisdiction like mine, where you're in a smaller jurisdiction, like I am in Central Oregon, it doesn't, you don't have to go too far to find somebody who works in the court system, whether it's a lawyer or a court clerk or somebody who works at the courthouse, somebody who works in law enforcement. I think that you really do yourself a favor by sort of asking those people, "What do you think of this judge or that judge?" Um, you usually will get a pretty honest opinion. So, not all judicial seats are contested, so a lot of them you don't really have to worry about because the incumbent is going to get reelected. But when it comes to the to contested races, I think it's a good idea to do your homework. I think that it is incumbent on every one of us, and I'm going to get on my soapbox for just a moment. We say at every election, never is there going to be a more important election than this one. This one, we're at some pivotal moment in history, and never is there going to be a more influential election than this one. We say it every 2 years, every 4 years, every election cycle. But I want you to understand that we all have a citizen responsibility to vote. And I worry about the fact that in a lot of jurisdictions, now I'm going to tell you about Oregon because I think Oregon is awesome. But in a lot of jurisdictions, there have it's getting more difficult to get to a poll and vote. And that's by design. Do not let that, don't let it defer you from coming. Don't let it scare you off. Don't let it deter you from going to the polls because every vote will count. I don't care what your political leaning is, who you're supporting. Y'all know I'm a defense attorney. I tend to be on the liberal side. I don't care who you vote for. That's none of my beeswax. It is none of my business. If you all want to talk politics sometime on a separate live where I don't have to subject the people who don't want to hear about it to it, we can do that. But what I will say is every one of us, if you are over the age of 18, you have a legal and moral responsibility to vote. I don't care how you do it, just do it. I had to remind myself that my address just changed, my state just changed. I needed to go back and renew and re-register in my new home state. And so I've done that already. There are a lot of opportunities, a lot of states you can register online these days. A lot of Department of Motor Vehicles, if you've changed your address and you go down and change your address on your driver's license, or you have to get a new license, they have a motor voter bill that says that at the DMV they hand you an application. So there's many alternatives, and please, 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 if you have neighbors who are having trouble getting to the polls, knock on your neighbor's door and say, "Hey, I'm going to go vote. Do you want to go with me? Do you need a ride?" You don't have to talk politics. You don't have to talk about who they're voting for. You don't have to stump for anybody. But it is critically important on every election, not just this one, every election, that we do our part to make sure that people get to the polls. Now I want to talk about Oregon. Easily 30 years ago, Oregon decided that they would do their entire election system by mail, and it is all vote by mail. And it has been incredibly successful. Now, I know y'all, there's all this talk about, mail-in ballots and people getting more than one and all of those things. But I'm going to tell you that the state of Oregon has done study after study about mail-in ballots. And I absolutely believe that we have no higher rate of voter fraud than any other state, and probably a lot lower than a lot of states. And one of the reasons I love it is because I can sit down in front of my computer. I can research, I can Google, I can figure it all out. And if I don't have 4 hours to sit down and do it all at once, I don't have to. I can set my ballot aside and I can say, I think I need to think about that for a minute. I think I need to get in touch with somebody I know who is involved in this issue, or I want to call my best friend. She's a teacher. I want to talk to her about how this bond measure is going to impact the community, and if it's really going to be good for teachers. Those are all things that we as citizens have a responsibility to do. And I love the fact that I can do that at my leisure. So I get my ballot and I have somewhere around 15 days to complete it and drop it back in the mail. And if there is a cutoff deadline. If you don't get your ballot in the mail, there are drop boxes right outside election headquarters, and you can drive through the drop box and drop your ballot off. Um, it is very convenient, and we have really seen an improvement in voter turnout as a result, because we're not requiring people to go between set hours. We're not requiring people to go during particular times. We're not requiring people to request absentee ballots if they happen that they're not going to be in town on polling day. And all of those ballots go to our county recorders. The county recorders all record all the ballots, and I will say that they begin counting ballots. The ballots that have come in advance, they begin counting those on the day of the election. And but they do get a little bit of a jump because they're able to take them out of the envelopes and get them arranged so that it can be fed through the ballot readers quickly. And so they do get a little bit of a jump on that. But if you are planning that you are not going to be around during the election, on election day, please request a mail-in ballot, an absentee ballot. Most states are very accommodating for that if you are not going to be in town on election day. So don't think just because you've got a business trip planned, or you've got to be gone, or there's an emergency that you can't vote. So that is my soapbox. Vote, vote, vote. I don't care who you vote for. Just get to the polls. And make sure your your vote counts. I also love. Oh, this is a good question, Jen. I also love all those people who volunteer at the polling places, and that's something I wouldn't mind doing now that I'm retired. How does voting work in the armed services? This is a great question. If you are assigned stateside, you can vote. In general, you can vote in the state where you are currently domiciled. You can also vote, alternatively, you can vote in your home state, your home of record. So you can choose one or the other in general. There are some exceptions. If you decide that you are going to vote for your home in the election in your home of record, then you need to request an absentee ballot. In fact, the whole idea of absentee ballots really came around to accommodate people who were in the military. If you are overseas, and you are deployed overseas, that the armed forces have a process where you get your ballots early and then they return them. So if you are not within the U.S., generally the individual bases provide a process for that. So that's a good question. If you'll recall, there was some conflict in the last election about whether or not overseas uh, military members' ballots were going to be counted and whether some of them came back in time. So that's a good question. Any other questions? If you were the DA, would you try the Karen Reed case again? Boy, thank you. I don't recall. You know, there's a lot that goes into this calculus. If I were the DA, I think I would not retry it, having seen the evidence. However, um, that's looking at it from a purely legal standpoint, looking at the law and looking at the facts and putting them together and saying, can I prove a case? What that calculus doesn't consider is the political ramifications. So the elected district attorney has got to get himself reelected. And Lally's not that guy. He works for that guy. And so I don't know that Lally is going to have a lot of say in the decision on whether to retry Karen or not. I'm pretty sure that's going to be above Lally's pay grade. Does he want to retry the case? I sure wouldn't. I mean, he pretty much got his head handed to him, and you know he got caught really have an egg on his face. So if the decision were up to me, I would not do it. But I think there is a political calculus that comes into this that doesn't necessarily track with reason. So that's a good question, though. Any other questions? Hi, Beth Riggenback. Do you think Wendy will be charged? This is a good question. Wendy Adelson, do you think she will be? Oh, and Eagles were your mascot. I went to community college for a couple of years, and their mascot was the Penguins. Go figure. In Vancouver, Washington. I mean, it's not like it was Alaska or South America. It was, penguins. So, yeah. And so, do I think Wendy will be charged? Some of this is going to depend on what turns up in Donna's trial. If there are more of these sort of incriminating text messages between Donna and Wendy, maybe. I think the other thing is whether or not Donna is gonna or Charlie will roll on Wendy. I think it's very unlikely that either one of them will turn on her, but it's always possible. And in that case, I think if there were more information from one of the co-conspirators about her involvement, then I think it's possible. Absent that, I don't, with what I've seen so far, I think the case against Wendy is much thinner than the case against Charlie and Donna. That's not to say it can't be made, but I think it's a tougher hill to climb. So I'm hoping that we're going to see some newly discovered information come out of Donna's case. Certainly, we're going to see the communication between her and Charlie and her and Wendy since Charlie's conviction. And Charlie likes to hear himself talk. You guys know that. So that could be interesting. The jail calls themselves could be pretty fascinating. So good questions. Do you think Judge White has been fair so far? Are we talking about the Black Swan case? Is that the judge in the Black Swan case? I'm having a little trouble keeping them all straight. It must be because I don't recognize that as quickly. I think he has been fair. I think that he has been a little frustrated with the defense attorney in that Black Swan case, and maybe understandably so. Um, I think that as I was watching it, I was thinking, "Dude, come on, learn the rules of evidence." Um, now, I mean, I have to be fair that when you are standing before the bar and you are facing down the jury and the judge and you are having to think about those things on your feet, it's a challenge. But I think that there were a couple of times that the judge was somewhat frustrated with him. There was this whole exchange about whether or not he was refreshing the witness's recollection and whether he was asking for this person's feelings and he really I thought the defense attorney sort of overstepped his bounds. The person who was on the stand was the victim's brother. They were both airline pilots. They were close, had both been in the military, were close to one another. And he, at one point, he he was called to talk about the relationship between Ashley and the victim. He was called to talk about how quickly they got married, those sorts of things. Um, the defense attorney was trying to bring out that he thought that this brother was interested in Ashley and wanted to date her himself. And so there was a text comment that the defense attorney construed or represented said one thing when it really said another. Um, so he and judges have a real hard time with this. Um, the cousin said he was his cousin, not his brother. The cousin said to Ashley, you know, "I'm here for you," sort of text. And then at some point, the cousin said, "Wrong, Benefield." The defense attorney interpreted that as you picked the wrong Benefield. You you married the wrong Benefield, is what he said. Um, that is not at all what the text says. The text just says the words wrong Benefield. No context to it at all. The defense attorney was trying to use that to impeach the guy to show that he had a reason to lie for Ashley because he had the hots for her. And it fell pretty flat. He made an offer of proof, and he basically he did say to the judge, the reason I'm offering this is to prove that this guy's a creep. And he was pretty adamant about it. And I thought it was inappropriate and definitely not something that you would say in court. Fortunately, he said it outside the presence of the jury, but the judge still admonished him about that and said, "Not okay. We don't call names. We don't impugn witnesses. You may impeach a witness," but then the judge pointed out to him that the text message did not say what he was representing it said. Then the defense attorney said, "Well, any woman would construe that to mean," and the judge just cut him off and said, "Don't go there." I'm not super impressed with this defense attorney, so I don't know where the case goes from here, or whether the judge is going to continue to try and rein him in. I know that there were a couple of interesting expressions on the faces of the prosecutors a couple of times when they came back from a sidebar. Um, the the dark-headed woman who was, I think she's the second chair, walked away and sort of looked at the other one and just kind of rolled her eyes after a sidebar. And I thought, okay, well, you know, um, that's not really okay either. You should be able to maintain your poker face a little better than that. But um, yeah. So I think at this point the 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 judge has been fairly fair. I think that at times he's had to sort of give the defense attorney a few guardrails, and that shouldn't be the case. Uh, they should not have to. A judge should not have to put up guardrails for the defense attorney. The defense attorney should know that without having the judge have to rein them in. Real happy 33. He's too tacky for me so far. Yeah, I didn't like the way he was behaving in court, and I didn't like his comment about any woman would see that as a flirtatious or whatever it was he said. So yeah, I do uh, I agree at this point. I think what surprises me the most is how fast it's going. I mean, a murder trial that's going to be wrapped up in 5 days is pretty surprising. So um, I could be wrong. It could go much longer. The defense attorney could pull a John Pryor and have a whole slate of defense witnesses. So we'll see. But it does seem to me like it's going pretty quick. So, other questions? What size are the finished blocks for the crane quilt supposed to be? Hi, they are supposed to be the here. This is a good question for all of you. The seam allowance is in the square, so the square should have two lines, an outside line and an inside line. The inside line is the 1/4 inch seam allowance. That will be the finished size of the block. And the blocks finish at, well, with the seam allowance, 6.5. So 6-inch blocks finished at 6.5 for the seam allowance. Black background, please. Any color crane you would like to make, and as many as you would like to make. I'm really hoping that I'm going to be able to get back to some quilting projects in the next 2 or 3 weeks. Kind of depends on how the book's going and a bunch of other things, but I do have a very nice area in the new house that is going to be sort of um, a, a den slash guest room, a spare den slash guest room where I'm going to be able to set up my sewing and be able to spend some time on some of my projects. So I'm excited about that. And the crane project has priority, so we will get that done just as soon as we can. So please, if you want to send a square, please do. The link is in our show notes, and it will link you to my Google Drive. Somebody said that they were having trouble pulling it up off my Google Drive. If that is the case, please email me and I will mail you a copy. And all of you peeps out there who keep sending me money when you send me an envelope and ask me to send you something, stop. I send it all back because I don't accept those kind of donations. That is all part of doing business. So I pay the postage to mail those things out to you if you need them. And so, and same with those of you who send me a self-addressed stamped envelope and a $5 bill for a bracelet, get out of here. So I send them back. So don't send me money, honey. We do accept donations if you want to send a super chat, but nobody's under any obligation to do that. We don't expect it. My whole reason for starting this channel was I found out that I loved connecting with the true crime community, and I missed it when I wasn't doing it, and so I started the channel to be able to connect with the community. So it's not a money-making venture for me. It is a way to let you know about my book and about new projects that are coming up, and a way to connect with you all, and because I just like it. So, any last questions before we wrap up for the night? Then I'm going to take my poor burning eyes and quit looking at the computer screen because, man, oh man, it is smoky and miserable. Uh, oh, I just got a message. Welcome back to the Northwest in spite of the smoke. Glad you're back. Where can I find your book? You will be able to find my book. Pre-orders are available through any of the major booksellers: Amazon, Barnes and Noble, um, uh, not Goodreads, BookBubs, I think it's called, the one that links you to your local independent bookstores. Your independent bookstores should have them. If they if you want to be sure that you get it the day that it becomes available, you might want to ask them to order it for you. It will be on the shelves on September 24th. It will be available for your Kindle, your e-readers, and it will be available for Audible all on that same day. We have picked the narrator for the book, and the final PDF has gone to the narrator to begin the recording for the recorded book. I'm super excited about that, and it will be available on the day the book drops. So thanks tonight for all of you being here. I appreciate it. I know that there's a lot of ways you could spend your Wednesday night, so I appreciate you spending it with me. And I'm going to say thanks as always to Jen, who is our fabulous moderator and keeps things moving. And I hope that I will see you all next week, and where we will have much more to talk about. If you have cases that you would like to hear me talk about, please send me an email, post it in the comments, or drop it in the chat. And I'm sure that I will get it, and we will dig into some of the other cases that you all are interested in. So let me know. And with that, I'm going to say good night. Have a great week, and I'll see you next week. Good night.